Good morning. My name is David Moroney, a partner in the Commercial Property Department. I'd like to welcome you all to the autumn edition of the Kuits Property webinar. During the next hour, our panel of experts will be considering the implications of recent changes and developments in the world of commercial property, ranging from biodiversity net gain to levelling up. If you have any questions throughout, please feel free to submit them via the Q&A tab, and time and IT skills permitting, we'll address as many as possible at the end of the webinar. So without further ado, I'd like to introduce today's speakers. Firstly, we have Sally Knight, a property partner within the property investment team, Adam Himes, a partner and head of the development team, Charlie Mallinson, a solicitor within the development team, Charlotte Barker, a senior associate in the investment team, and last but by no means least, Steve Jackson, a partner in the landlord and tenant team. So with these brief introductions over, I'd like to hand you over to Sally.
Thanks, David. So the first topic we're going to start with today is biodiversity net gain. Now, I did think I'd be talking to you today about something that was going to be implemented in November this year. But as always, there has been some very recent developments. And just last week, the government indicated to the BBC that the framework will no longer be introduced this year and is likely to be implemented in January 2024. So the biodiversity net gain was initially implemented by the Environment Act 2021 and intends to enforce a biodiversity net gain requirement for all planning applications. The delay has probably been brought about by detailed regulations which we are still awaiting and which haven't yet been implemented by the government. There have been calls for a transparent delivery roadmap and clear timescales, and some recent quotes in respect of the latest delay come from the British Property Federation, who stated that the delay will cause more uncertainty at a time when the industry is calling for greater clarity and consistency. And the Home Builders Federation said that significant gaps in government guidance would not only prohibit local authorities' abilities to effectively manage this new requirement, but inevitably lead to further delays in the planning process. So, notwithstanding the delay, what can we expect when the gain requirements are enforced? Well, in essence, all planning applications are going to need to show a net gain of biodiversity on the site in excess of 10%. That requirement is going to be enforced by local planning authorities via the planning process. Change of use applications will be caught, and there are only going to be limited exemptions to the requirement. So initially, residential developments of less than 10 homes will be exempt until around April 2024, although with the recent delays, we are waiting to find out whether that transitional period will be extended. Permanent exemptions are set to include permitted developments, householder applications, and small-scale self-builds. So how's this going to work in practice? Well, a biodiversity net gain assessment will be required as part of any pre-application preparation. That will usually be undertaken by a specialist ecological consultant. The assessment must include a plan for the protection and retention of biodiversity at the site. The standard to be used will be the biodiversity metric calculation tool issued by Natural England. That metric can produce a zero baseline for biodiversity. So for example, if you have a sealed surface, an existing building which is being redeveloped, or a tarmacked surface, for example. As part of that assessment, it will be necessary for the developer to develop a biodiversity net gain plan. Now, there's hierarchy set out within the legislation, and you can see on the slide there, it will be necessary to work through those in order. So initially, you have to look to avoid a biodiversity impact. That might be through site selection or site layout. If that's not possible, you must look to minimise any impact. Moving on to restoration if minimisation isn't possible. And then the final option for the developer themselves will be offsetting or compensating for the loss. That might involve the creation or enhancement of an off-site habitat, or it might involve the purchasing of biodiversity units, which I'll come on to shortly. If none of those options are available to the developer, then they're left with the backup option of last resort, really, which will be purchasing biodiversity statutory credits from the government. Now, planning authority is initially going to impose the net gain requirement via a condition on a planning application. They're going to require that a net gain assessment is carried out and a net gain plan is submitted to and approved by the local authority. They will then be imposing ongoing obligations on the developer, either via conditions or Section 106 agreements, for example, in the usual way. There has, however, been a new concept of agreement called a conservation covenant introduced by the legislation. So these new agreements are between landowners and either the relevant Secretary of State or a delegated public body, such as a local authority. And that will allow a landowner to bind the land for a period of time in order to secure long-term conservation benefits for the public good. The concept of these agreements has been designed to enable the creation of a market for biodiversity units. Now, there will be scope for developers, for example, to sell excess units. So if you're carrying out a development where you have in excess of 10%, significantly in excess, for example, you may look to sell some of those excess units to another developer who needs to look at an off-site compensation option. There may indeed be some landowners who look to utilise their land purely for biodiversity net gains outside of the scope of development in order to sell those units in this emerging market. In order to do that, it's going to be necessary to register the site on the biodiversity gain site with the government. It's going to be really important for landowners and investors to be aware of these Section 106 requirements and these new conservation covenant agreements. And the due diligence on future purchases will be all important. There are going to be within these agreements recovery provisions put in place by the local authorities. So, for example, a future investor will inherit the liability for having failed to properly implement a net gain plan or for meeting any ongoing obligations, which are likely to be in place for a minimum of 30 years. So we do await the final details, and it does remain to be seen how smooth the process is going to be with each of the local authorities. The government has been at pains to stress that it's already committed more than £15 million to help councils prepare and recruit new specialists. But a spokesman for the Local Government Association told the BBC just last week that councils urgently need confirmation of go-live dates, essential guidance and definitions, and a clear timetable of funding in order that they can employ additional staff and invest in the expertise and capacity required. So it is set to be a steep learning curve for all involved in the planning process. So that's a snapshot of biodiversity net gain and where we are at the moment. And I'm going to hand over to my colleague Adam now, who will talk to you about some recent planning case law.
Hi there. So thanks very much, Sally, for that talk. As Sally mentioned, I'm also going to be talking about planning matters. I'm talking about the much debated planning case relating to the flagship Marks and Spencer's store on Oxford Street in London. The building's a famous landmark outlet on one of London's most well-known streets near Marble Arch. Now, just by way of very brief history, in the 1920s, the Portman estate, who owned land in this part of central London, wished to build on land between Orchard Street and Edgware Road. Orchard House, which was a 6-storey commercial building on the corner of Oxford Street, was developed speculatively between 1929 and 1930. This is now the M&S building in question, having been greatly extended and modified over the years. So over recent decades, Marks and Spencer have come under the same competitive pressure from online retailing, COVID, and other challenges, as have department stores and other similar retail outlets. So M&S therefore proposed the demolition of its Marble Arch store and its redevelopment for mixed use, including a smaller Marks and Spencer's within that site. M&S submitted a planning application in June 2021 for the demolition of the existing buildings on the site and the construction of a 2-basement ground plus 9-storey mixed-use development, including retail, cafe, restaurant, office and gym, as well as pedestrian arcade, public realm and associated works. So that's the background to what they wanted to do with the building. Now, notwithstanding planning inspectors' positive recommendation for consent, on a called-in application, the Secretary of State refused to grant planning permission. And in rejecting the plans, the Secretary of State focused on two main aspects, which are heritage and sustainability. In terms of heritage, a significant factor in his refusal, being given very great weight, was the harm that the new building would cause to the setting and significance of designated heritage assets. In particular, the proposed development was considered to be prominent and distracting from the Selfridges facade, which is nearby to the existing Marks and Spencer store. So in opposing the Secretary of State's position and to justify redevelopment, much was made of the fact that the existing building was a non-designated heritage asset, which means that although it had some heritage value, Historic England had not given it listed building status. Now, nonetheless, the Secretary of State reiterated comments made by Historic England that the existing M&S store had stylistic similarities to the Selfridges shop, and great play was made of the point that the loss of the existing building amounted to a missed opportunity to retain, reuse, and adapt the good quality elements of the site. Now, the very great weight placed on heritage assets impact in the decision may encourage local planning authorities to be extremely cautious when considering planning applications which might impact on surrounding listed buildings, even if the application site isn't listed itself. And it provides an example here, as I say, with M&S neighbouring Selfridges being considered very heavily in the SOS's decision in this instance. Sustainability was the other consideration, and a further main justification in the Secretary of State's decision was that existing materials should be kept at their highest use for as long as possible. Now, what this means in simple terms is retrofit, not redevelopment. And it suggests that developers must now be able to demonstrate that the building can no longer be used in its current form, with the only real option being demolition. So the Secretary of State has set a very high hurdle in this regard, which can't be ignored by applicants. And specifically here, the Secretary of State said that the development was clearly not net zero carbon because of a substantial amount of embodied carbon involved in the construction. The implication again being that developers must not only set out alternative schemes which are less carbon heavy, but must also consider the life cycle of carbon and explain why current structures are not possible to be retrofitted. In this case, it was specifically suggested that the carbon utilised would obstruct the UK's net zero target and wasn't generally supportive of the transition to net zero, and it would go against the reuse of existing resources. So what does this mean in terms of future consideration? Well, in general terms, the decision suggests a change in government policy. It may signal a shift towards retrofit and away from wholesale redevelopment, particularly where factors are similar to those in this particular case. And perhaps it's an indicator of government plans to introduce carbon legislation or further similar developments in the near future. Just by way of further example, Westminster City Council's cabinet member for planning said in this case that the council's position was to encourage landowners to refurbish buildings, not to demolish them. So more specifically, this case shows that better data is really needed to more accurately calculate whole life carbon assessments. And furthermore, design for planning submissions will likely need to be more detailed to be able to better assess carbon impact. And developers will need to procure contractors much sooner so that they can input these more detailed designs to ensure low carbon solutions and to be deliverable during construction and to commit to any net zero targets which may be set. So all in all, this will have cost implications for developers and landowners. And in a wider sense, this case does raise planning issues which can't be ignored by developers or landowners in any case. So I'd now like to hand over to my colleague, Charlie Mallinson, who's going to talk about a property case.
Thank you very much, Adam. As Adam said, I'm still going to be talking about planning, but rather than planning at the outset of the matter, I'm going to be talking about planning once it's in place. So the basic facts of this case are that the landlord, T&M Property Investment Limited, let out a premises in Wilmslow Road in Manchester to its tenant. The use of the property was permitted by both the lease and by planning for use as a cafe. However, during the course of the lease, the tenant made changes to the shop frontage and it changed the use from a cafe to a shisha bar. Now, the change of use and those works were done without the consent of the landlord, and they were also done without the consent of the planning authorities. Manchester City Council became aware of this breach of planning and it issued an enforcement notice requiring reinstatement of the works, and it required the reinstatement for use as a cafe. What's interesting here is that the council issued the enforcement notice on both the tenant and on the landlord. And it was completely within its rights to do so. An enforcement notice attaches to the land rather than the party in breach. Now, the notice was ignored by both the tenant and the landlord. They took no action whatsoever. The tenant continued to use the premises as a shisha bar. The landlord continued to collect the rents and didn't do anything to stop the use. Becoming aware that this enforcement notice had not been followed, the council prosecuted the landlord for non-compliance with the notice. Now, non-compliance with an enforcement notice is a criminal offence. And the judge fined the landlord £18,150 and awarded costs of £5,700. So before we've even got into what makes this case more interesting, the landlord, through no fault or through no perceived fault of its own, it was the tenant who had been in breach, the landlord is down almost £25,000 plus any of its own costs. Now, as I mentioned before, non-compliance with an enforcement notice is a criminal offence. And as the landlord had therefore technically committed a criminal offence, the council took steps one part further. The council made a further application under the Proceeds of Crime Act, requesting that any gains that the landlord had made from this unlawful use be recovered. And this application was successful. As such, rent paid to the landlord was deemed to be those unlawful gains. And in total, an order for £174,074 was made against the landlord. So the landlord is now, disregarding its own costs, over £200,000 worse off, simply because it didn't follow the enforcement notice. So what are the implications of this for landlords? Well, the decision and, of course, those related consequences should be seriously considered by any landlord. An enforcement notice, as I've mentioned before, but as I will stress again and again, it attaches to the land rather than the party in breach. And therefore, any inaction on the tenant's behalf or a breaching party's behalf is an inaction and a responsibility of the landlord. In this case, the landlord had tried to raise a defence. The landlord had tried to say that there were adequate provisions within the lease that required a tenant to comply with all laws and legislation. And whilst the lease did contain such a provision, it was found that this was not sufficient. This is not a sufficient defence. In other words, those lease provisions are a sword by which the landlord can enforce enforcement, but they are not a shield that the landlord can hide behind to absolve itself of its responsibilities. So the next question, therefore, really has to be, what does this mean for you as landlords? Well, it shows that you need to be proactive in ensuring that tenants adhere to any planning responsibilities and requirements. So to start off with, you can't simply let out a property and think no more of it, collect the rents, but never have any involvement. There does need to be some level of involvement and making sure that what you have permitted the tenant to do is what the tenant is doing. But more importantly, if you do identify a breach, you need to take steps to enforce the provisions within the lease to make sure that the tenant is remedying that breach. As we've seen from this case, just because the tenant has committed a breach does not mean that you as the landlord will not be found responsible. So where you do identify a breach, you must take steps to remedy that. And in this matter, this was discussed. How far does a landlord need to go? Obviously, in this case, no action was taken whatsoever, and so anything is better than nothing. However, in the first instance, simply enforcing it, telling the tenant that they are in breach, that they need to make a change. But ultimately, in this case, the landlord could have forfeited the lease. And if that was the only way that landlord could ensure compliance with the enforcement notice, then that is what would be expected. And as we see from this matter, if the landlord does not take those steps, if the landlord does not ensure compliance with the planning responsibilities, then the consequences for the landlord can be extremely significant. And on that note, I'm going to pass over to my colleague, Charlotte Barker.
Thanks, Charlie. Really interesting topic and some useful takeaway points there. I'm going to be speaking about the Levelling Up and Regeneration Bill, which was one of several bills first mentioned in the Queen's speech back in May 2022. The bill is currently on its third reading in the House of Lords before there will be consideration of any amendments, and then it will receive royal assent. The purpose of the bill is essentially, as it says on the tin, to level up the UK. And it intends to do this by growing the economy in places that need it the most, regenerate towns and cities, and improve the planning system to streamline the process for applicants, but also seek to control how developments are carried out. More specifically, in relation to developments, the bill aims to ensure new developments have adequate infrastructure and include affordable housing, with emphasis on designs reflecting community views. I'm going to talk to you today about a few key sections of the bill, with a particular focus on planning, development, and affordable housing. The first point to mention, and this is thought to be the most widely anticipated change from a financial perspective, is the introduction of the new infrastructure levy, which would replace the current securing of developer contributions via the Section 106 agreements and the Community Infrastructure Levy, or SIL process, as it's better known. The new infrastructure levy, or IL, will involve rates determined by local planning authorities as opposed to being set nationally. The levy will be based on the final gross development value as opposed to SIL, which is based on the floor space of the development when planning permission is granted. This means that rates will be tailored to local circumstances with the aim of delivering as much on-site affordable housing as possible. Any reliefs which may be available to infrastructure levy, as there are with SIL, that could be available are awaited, and we will keep you updated as the bill progresses through. The second section to mention, and this is what planning consultants are actually referring to as the game changer, is the new provisions to allow minor variations in planning permissions. This is particularly important and perhaps being described as the game changer because the likelihood of planning permissions progressing and requiring no changes is extremely rare. The bill proposes the introduction of a new Section 73B in the Town and Country Planning Act, which would expand the existing powers under the Act to vary or remove planning conditions attached to grants of planning permission and make non-material amendments to a planning permission retrospectively. This is something that isn't possible at the moment, or if it is possible, it requires many applications and time and costs to be spent. Section 73B will offer a new route to vary an existing planning permission, allowing greater flexibility for making non-substantial changes to planning permissions This would also include changes to the description of the developments and conditions imposed. So currently, when submitting planning permissions, developers would tend to keep the description of the development purposely vague, so as to allow them to streamline and introduce specifics as they go along. But now you can have a description, or will be able to have a description and then potentially change it. This would do away with the need for multiple submission of applications under different routes, which will obviously save time and costs, which is important for developers. Another section to talk about is the design code section, and the bill intends to strengthen the role of the National Model Design Code to ensure that locally informed and clear design standards are in place in all parts of the country. It includes a provision that would require every local planning authority to produce a design code for its area, which will have full weight in making decisions on development. Area codes will act as a framework for which subsequent detailed design codes can come forward, prepared for specific areas or sites, and led either by the local planning authority, neighbourhood planning groups, or by developers as part of planning applications. Essentially, it will explicitly and in a very detailed manner set out a series of expectations, as well as guidance on how development should be carried out. Now, this may appear to be very stringent as against the current regulations, but importantly, for developers, it will offer transparency and certainty on what the expectations are, so there will be less intervention required later on in the process. The final aspect of the bill that I want to talk about is the letting of vacant high street premises, which could be potentially controversial. The bill proposes to grant powers to local authorities to require landlords to put certain vacant premises, high street units, up for rental auction, depending upon the importance of the location, its suitability for certain uses, the length of time it has been vacant, and the benefit to the economy in it being occupied. To achieve this, the local authority must serve notice on the landlord, who has the right to appeal, but only on prescribed permissible grounds, which may be difficult to achieve or not a likely scenario. So, for example, where the landlord needs to retain possession to carry out construction works, demolition, or reconstruction. The rental auction can be arranged if no letting or license, which must be obtained with local authority consent, has been created upon expiry of the notice period set out in the notice. Now, there are some practical implications of this introduction or potential introduction. It gives the local authority increased discretion. It allows them to designate certain areas as high streets, decide which premises are suitable for the high streets, and decide which tenants should occupy. For landlords, it creates the problem of potentially forcing them to contract with those who they may not have chosen to do so, and also on terms which they didn't agree and may not be favourable. For lenders, there's also a potential issue because there is the increased risk that local authorities have the ability to override carefully negotiated protections. And there is the possibility that lenders may start demanding covenants from borrowers to not be in a position for authorities to force a letting. So landlords will have to ensure that premises are let so as not to give the local authority the potential ability to let the premises for them. We will await further updates as the bill progresses and provide updates as and when we hear. But if you do wish to discuss any aspects of this in the meantime, please get in touch with our commercial property team. I'll now hand over to Steve Jackson, who will be talking to you about the registration gap. Thank you.
Morning. I'm going to talk to you today about the registration gap. And during the late noughties, the core business of HM Land Registry fell by around 75% due to the dire state of the economy and in particular the housing market. This resulted in the Land Registry making a £130 million loss in 2009 and the workforce, which stood at around 8,665 in March 2005, being reduced by around 1/4 to about 6,000 now. These staff reductions have resulted in exceptional delays in the processing of applications. In 2005, 89% 98.7% of all applications were processed within 20 days of receipt. Moving forward to 2023, even the simplest of applications are taking, according to HM Land Registry figures, up to 12 weeks to process, with a more complicated transaction taking anything up to 2 years to register. This presents all users of HM Land Registry's services with a big problem. What happens between completion of the purchase of the property or completion of the lease and the date that the registration is completed? So the legal position is, from the date of completion of the transaction until completion of the registration, the legal estate remains with the previous legal owner. For example, the seller in the event of a purchase or the original tenant in the event of an assignment of the lease. The gap between completion of a transaction and completion of its registration is referred to as the registration gap. So why is the registration gap an issue? There's a number of practical reasons. So firstly, a notice relating to an interest in land needs to be served on the legal owner. So why is that a problem? Here are some examples. Take an example of where there is a landlord and tenant relationship and the landlord has disposed of their interest in the property. This was the situation in a case called Stodday and Pye. In this case, a notice to quit an agricultural tenancy submitted by the purchasing landlord was not valid as they were not the legal owner. It should have, during the registration gap, been served by the selling landlord. Where a buyer landlord has to serve notices under Landlord and Tenant Act 1954, there are also issues. Where they need to serve them on a tenant, but their interest has not yet been registered at the land registry. They can't do so, which can present severe problems to landlords as notices are often time critical. Thirdly, where an enforcement notice has been served by the local authority relating to property, the seller remains liable to deal with it until the registration of the buyer's purchase is completed. This was held in a case called East Lindsey District Council in Thompson. As well as notices, loss of priority is also an issue for the following reasons. So firstly, when an application is made to the land registry, it is protected by a priority search. That search guarantees that nothing will change on the title to the property between completion of the purchase or lease or assignment and submission of the application for registration, assuming it's submitted within the priority period of the search. If priority is lost during the registration gap, for instance, because the application is cancelled for some reason and the priority searches have not been kept up to date, then you risk having adverse interests registered in priority to your application. An example of this was in the case of Baker and Craggs, where Craggs bought land and during the registration gap, his priority period expired. In the meantime, Baker bought land and registered an easement over Craggs's new property. Craggs's land now became subject to Baker's easement, an issue that wouldn't have arisen without the registration gap. A third issue with the registration gap can arise when trying to deduce title. So if the land in question, for instance, is development land, statutory undertakers require evidence of legal title, which can't be provided and can lead to missing key development deadlines. It can also cause similar issues if the land is being sold during the registration gap. And finally, enforcement of covenants can also be another problem. The registered owner must be the person to enforce covenants affecting land. This means that during the registration gap, the legal owner has to join in any action, which means that you not only have your own legal costs to pay, but also likely their fees too. And unless the appropriate provisions are drafted into transaction documentation, it can be very difficult to persuade the legal owner to become involved in litigation in the first place. So what can be done to mitigate the effect of the registration gap? So firstly, it can seem like an obvious one, but make sure the applications are submitted quickly to the land registry after completion of the transaction, so as to minimise the period of the registration gap. Secondly, the received wisdom is to be proactive and request updates from the HM Land Registry with regards to your pending application. In fact, my experience, this isn't likely to offer you with any joy. Of more use is, however, when there's a dependent application to the one at the land registry, for example, a sale of the land in question during the registration gap, then you can apply to the land registry to expedite the application, which does have a positive effect on the length of time it takes to process it. Thirdly, continually renew your land registry priority period searches during the registration gap. And finally, it's a good idea to draft into the relevant documentation a requirement to oblige the seller to serve any notices during the registration gap. This is not always easy to agree with the seller, but can be invaluable if present in the documents. Due to the land registry staffing levels, the registration gap is not likely to be to improve in the future, in the near future at least. If you have any issues that arise during the registration gap period, it's really important to seek legal advice to ensure that you do not fall foul of the registration problems discussed by me today. So that's it from me on the registration gap, and I'll pass back to Sally to discuss the Renters Reform Bill.
Thanks, Steve. So our final topic for today is the Renters Reform Bill. The Renters Reform Bill was introduced for its first reading in Parliament in May this year to much fanfare from the government. And you'll see there from the slide, the purpose was stated as ensuring that private renters have access to a secure and decent home, and that landlords retain the confidence to repossess their properties where they have good reason to. The government highlighted the need for reform given the doubling of the private rental sector since 2002 from around 4.6 million to 11 million. So what reforms are proposed? Well, the reforms will be made to the Housing Act 1988. The most notable reform, and the one that's made the most headlines, is commonly referred to as the abolition of the no-fault eviction, or Section 21 eviction. At the moment, assured short-hold tenancies have an initial fixed term, and after that fixed term has expired, a landlord can serve a Section 21 notice without any default on the part of the tenant seeking possession of the property. What's actually proposed by the reforms is the complete abolition of assured short-hold tenancies. The intention is that this will apply to any new tenancy after the enactment and to any existing tenancies following the expiry of their initial fixed term period. Those new tenancies will then become full periodic assured tenancies, and they will roll on a month-by-month basis from the very outset. This is intended to apply to all residential tenancies with an annual rent in excess of £750 per annum, or £1,000 in London, and less than £100,000 per annum. So you can see that the intention is it will apply to the vast majority of residential tenancies. So these tenancies will then only be terminal by the landlord on one of the grounds provided for in the Housing Act. There are some proposed amendments to those grounds in order to give landlords some security in various new instances, given the abolition of the Section 21 no-fault ground. So notably, own occupation will be introduced as a new ground for possession, and this will allow a landlord to evict if they or a very close family member intends to occupy the property. The caveat being that that will only be permitted after the first 6 months of the tenancy has expired. Rent arrears will remain as a ground with the usual standing 2-month arrears at the date of a possession notice, but there will also be a new ground for persistent arrears or late payments. Now that's defined as arrears of at least 2 months' rent, unpaid for at least a day, on 3 separate occasions within a 3-year period. The tenant's conduct ground is being slightly amended to make it easier to evict on the grounds of poor conduct, and it's amended to conduct which is capable of causing a nuisance or annoyance rather than likely to cause. There will be a new ground if landlords intend to dispose of the property. Again, this will only be applicable after the first 6 months of the tenancy has expired, and it's currently unclear what evidence the court will require in order to show that you have a true intention to sell. So the result of these changes is that landlords are going to need to seek court possession proceedings much more frequently. The government has recognised in the bill that delays can be caused by these types of proceedings and that there is nervousness in the industry around that point. So there's reference in the bill to setting up a modern digital service with end-to-end digitisation of the process, and that the government is working to explore prioritisation of certain cases in the court system. But it remains to be seen what the detail will be in terms of a more efficient and speedy court process. So other notable changes within the bill will include rent increase. So rent increases will be limited to once a year and will require a 2-month notice period in order to allow tenants to have a right of appeal to the first tier tribunal. And tenants will be able to appeal if they feel that the rent that's been imposed is in excess of the market rent for that particular property. It's intended that a compulsory ombudsman scheme will be introduced, and that's intended to resolve disputes between landlords and tenants. There is some controversy over the fact that that scheme is likely to be paid for by landlords. And then there will be a privately rented property portal. That's intended to be a register of all residential landlords and residential properties. And the idea will be that registration is required before the property can be marketed for rent. So the main takeaway on this topic today is that the bill still hasn't had its second reading in Parliament and therefore remains subject to some really significant amendment. There has been some support from tenant groups, although many of them are calling for the bill to go further. And unsurprisingly, there's been very little positive reaction within the buy-to-let investment sector. Agents are particularly concerned that this will put landlords off this type of property, leading to a decrease in available rental properties in an already very in-demand sector of the market. So latest reports suggest that there is some doubt over when the second reading in Parliament is likely to happen. Parliament's currently in recess for party conference season, and the King's speech is due on the 7th of November. So that leaves us with a very small window left for a second reading. There's been significant resistance from backbench MPs, and with the general election looming, it remains to be seen whether the government will look to prioritise appeasement of the backbenchers or appealing to the voting public by pushing through some of these reforms. A spokesman for the Department of Levelling Up Housing and Communities recently told the Telegraph newspaper that the government remains absolutely committed to delivering a fairer private rented sector for tenants and landlords through the Renters Reform Bill. The bill, which delivers our manifesto commitment, is progressing through Parliament and second reading will follow shortly. So still fairly vague. It has been reported over the last week that Michael Gove has this week reassured delegates at the Conservative Party conference that the bill will receive its second reading in the autumn as soon as business permits. So we will have to watch this space. So on that note, that concludes what we had to say for today. I'm just going to hand back to David, who will wrap things up with some questions.
First, I'd like to thank all of our speakers. I'm sure everyone listening has found this session both interesting and thought-provoking. As we have a little time left, we can address some of the questions which have been raised. So, looking firstly, a quick one for Sally. Sally, could you expand on the implications and how the Renters Reform Bill will possibly relate to student accommodation?
Yeah, so student accommodation is a really interesting one. It's been quite contentious because the nature of student accommodation is quite specific to the academic year. So landlords are concerned that normally they would be letting a property in advance for next year's students, perhaps in January, February of a particular year, ready for accommodation to be let from September to September. Initially, the reforms were intended to treat student accommodation in two different ways. So they were going to allow purpose-built student accommodation, so for example, halls of residence, to be let in a particular way which would suit that academic year, but privately let student accommodation, so just houses of multiple occupation, for example, with private landlords, was intended to be dealt with in the same way as all other residential tenancies. The difficulty for landlords in that situation is that tenants will be permitted to terminate those periodic tenancies on 2 months' notice at any time. So you can imagine a situation where a university landlord, for example, might suddenly be receiving notice that it's going to get that property back in April, which doesn't really suit that kind of investment. Michael Gove has very recently indicated that the government will potentially look to accommodate some concessions for that type of industry and potentially allow qualifying student lettings to be terminated at particular times during the academic year. So we're going to have to keep an eye on the consultations and how those amendments might pass through Parliament.
Thank you, Sally. Now, a quick question for Adam, please. In light of the M&S case, is there anything that the government could potentially do to assist landowners and or developers?
Yeah, thanks, David. So I think my answer to that is going to be relatively brief because the devil's in the detail in these things always. I think the two aspects I was talking about were heritage and sustainability. So on the heritage front, I think it's difficult because I think all planning cases are judged on a case-by-case basis, and it's clear that this property was in a particularly sensitive area of London, or it couldn't be much more in the spotlight as a specific location. So I think that has to be borne in mind when looking at the decision from a heritage perspective. But I do think on the sustainability front and the carbon sort of aspect, the government does have a role to play. And I think what the government could be doing is looking to set sort of minimum criteria for carbon assessment so that the developers know, again, on a case-by-case basis, perhaps where the line for the need for demolition versus retrofitting, rebuilding actually lies. So some sort of legislation or assistance from a statutory basis as to where that line lies, I think would be very useful. And I suspect that it's quite possible that legislation may follow in that regard. So hopefully that answers the question.
Thanks, Adam. Now one for Charlie. Would the same approach be taken if it was just works going on at the property?
I think the short answer to that is yes. Obviously, in this case, it was sort of brought about by the change of use, and that was what sort of prompted the council into taking the action that it took. However, I think going forward, there must now be a real concern that because the council has seen that this approach is not only permissible but actually very effective, that this could be a new tool in the armory of any planning authority. And yeah, so if works are done without planning permission, that is a breach of planning. An enforcement notice could be served, and then these actions could be taken if the consequences do go on. However, I think if it were just works in this case, one thing that would point out is that I don't think that the actions that a landlord would take would be far more wide ranging. With the T&M case, it was the idea that they really could have served a letter, and then pretty much if they didn't do anything, their next action was forfeiture. If it were just in relation to the works, it's highly likely, I don't know 100% on this case, but I think it's highly likely. I know that all of our leases here at Kuits all contain a provision that would allow the landlord to serve a notice to say you're in breach of something, and if the tenant didn't take the requisite steps, then the landlord would be able to enter the property and do those repairs in default. So if it were just the works, then it would be far simpler for the landlord to ensure compliance than with the change of use. However, I do think it is worth pointing out that this is something that will now be in the armory of councils up and down the country. So it really is, that proactive engagement will be required.
Thanks, Charlie. I'm conscious we have other questions, but time is starting to move against us now. So if anybody has anything further they'd like to discuss or any other questions, please obviously feel free to contact us at any time and we'll do our best to assist. So finally, to conclude, I'd like to thank all attendees on behalf of both Kuits and the Commercial Property Department for joining us today, and also for anyone watching on a recording. We hope that you'll join us again in the future for further webinars. Thank you.